On this episode of Law Weekly, we'll look at certain provisions of the Electoral Act 2022 and whether there's a need for an amendment. We have the views of a senior advocate of Nigeria, Adeluola. Also showing on the program, Lagos State commences prosecution of Vandi, the policeman accused of killing Lagos-based lawyer Mrs. Bolanle Raheem, as the deceased is finally laid to rest. Plus a recap of some of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. As we count down to the very important 2023 general elections, we're sticking with a critical look at certain provisions of the Electoral Act. My guest, senior advocate of Nigeria, Adeluola, studied law at the University of Lagos. He was called to the Nigerian bar in 1988 and has practiced for about 35 years. In recognition of his sterling qualities as an advocate, he was elevated to the rank of Senior Advocate of Nigeria in 2021. I began this interview with his general views on the Electoral Act.
The workability of that act will largely depend on the electorate themselves. The politicians may have their agenda, they may want to do funny things, but we as citizens must ensure that the elections come and go in such a way that we can still maintain a bond. I'll give an example. There are electoral offenses in that Electoral Act. Some of those offenses are such that you as a citizen must guard your vote. For example, you shouldn't have someone come to the polling unit with 2 voters' cards. It's an offense. It talks about political meetings, not even the election. That is, even before the election, people should not be disruptive of such political meetings. So we are going to start from the bottom up, and everyone is a participant. It's not about the contestants alone, it's about us. So you have electoral offenses, you have such breaches of the Electoral Act, people mutilating ballot papers, running away with them. Those are offenses that all of us should ensure we guard against. There are so many other provisions, provisions such as what a returning officer ought to do. We must hold every one of them to account.
Do you share the view that Section 65 of the Electoral Act, which empowers the returning officer to return and review his decision, is an affront of the powers of the judiciary? I ask this question because Chief Wole Olanipekun, former president of the Nigerian Bar Association, recently described this section as very dangerous to the country's electoral system.
First, let me make a correction. What that section does is it empowers the returning officer, the chief electoral officer, to return whoever has won. It's only the commission that can override that within 7 days, not the returning officer himself. And when that is done, it is done for some reasons that the return was not voluntary, that was not in line with the law or the guidelines and the regulations. But it then has a proviso which says that the decision can be taken before a tribunal or a court of competent jurisdiction. The only problem, well, to that extent, I think it has been taken care of. I mean, what our fears have been taken care of. But the larger consideration is we must look at the environment in which we are operating this Electoral Act. If you overturn a decision within 7 days, there will be chaos. So we don't want a situation where we have an election and then the country grinds to a halt. If there is any problem with the return, then you must leave it to the participants to go to the tribunal, which they're empowered to do by constitution. So we don't want a returning officer who just simply says, oh, it was not voluntarily returned, and then he wants the commission to reverse it. That shouldn't happen. I think we should expunge it. Once you have made the decision, you must allow the parties who are not satisfied to go to the tribunal or the court.
Now, I'm still going to stay with the Electoral Act. Some people have specifically gone to court to challenge certain provisions of the Electoral Act. They've sued INEC, and one of the questions they've asked the court to determine is whether, upon the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022, it is not unconstitutional for INEC to use or deploy the BVAS or any other similar device for the accreditation of registered voters in the 2023 general elections. Now, they specifically cited sections 50, subsections 2, sections 60 and 62 of the Electoral Act and whether in view of the unassailable fact of unavailability of telecommunications network coverage across substantial part of Nigeria, it is not unreasonable and impracticable for the defendants to use beavers for the accreditation of registered voters for the elections.
Well, the Constitution allows us to have elections where individual voters are able to vote, to cast their votes. The votes are collated and the returns are made and a winner is declared. Now, the Bimodal voter accreditation system is reliant heavily on power and communication. Now, the question is, do we have these facilities everywhere in our nation? The clear answer is no. Now, you don't want a situation where some people in some jurisdictions are made to use that for accreditation, and in other parts, they can dispense with it. What that means is, you can find somebody who is, who's been mischievous, say, oh, this beavers is not working. He wouldn't use it, and then manually accredits people who come before him for the voting. Then we have double standards. Those are issues that we must avoid. We must ensure that at the end of the elections, we are all happy with the process and the outcome. The process is also very important, even before we come to the outcome, so that everyone is happy, and it's also part of the process of getting our country into a stable democracy. You see, we would not be able to just jettison it unless you want to have an amendment to the law. I mean, it's there already in the law. So it's not just going to be a question of discretion for INEC, whether they want to use it or not. It's in the law. So if you're not going to use it, then it has to go through a process of amendment of the law. And if you begin to tinker with such things at this point in time, then you are not giving enough confidence to those who are going to participate. And I keep saying, those of us who are citizens, those of us who are voters, are the ones who must ensure that the outcome of the elections are such that we are proud and we can say that whether my candidate wins or not, I'm glad that we went through this process.
Staying with the issue of the Electoral Act, and because you've also talked about electoral offences, the INEC chairman has consistently called for an electoral offences court. Do you share the view that we need such a court to tackle electoral violence and rigging?
Electoral violence isn't the only problem that we have in terms of electoral offences. There are people who will stuff their pockets with voters' cards that don't belong to them. These are people who will tinker with the process and the outcome. There are people who will get to places, steal ballot boxes and papers and run away with it. It's not only about people carrying machetes or people carrying knives or guns. So if we want to have separate courts for those people, now you may find at the end of the day that when you prosecute such people, the outcome of the prosecution might actually show that the outcome of the election was faulty. Then do you now take the judgment of the criminal court then to the civil court for use as evidence of the bad way that the conduct of the election has been done? So you see, I think we should just simply have these tribunals that we have today, and if there's anything to be dealt with, we should be empowered to do so. And in any case, the penalty for the offences ranges from 500,000 to 1 million, and in some cases 12 months imprisonment. How much of our resources do you want to expend to put somebody in jail for 12 months or to fine him 500,000 naira? Unless you want to make the punishment more stringent.
Now let's leave the Electoral Act and move on to the Constitution. Former President of the Nigerian Bar Association, Olisa Agbakoba SAN, recently raised some questions about what he termed the ambiguous nature of Section 134 of the 1999 Constitution. But do you really think that there's any ambiguity in that provision?
I think I agree with my learned brother Silk, Mr. Agbakoba. If you say, and I know what you're referring to, it says that whoever becomes president, who's going to become president, must have won 25% of the votes in at least 2/3 of the states of the federation. And clearly, 2/3 of the states of the federation will give us 24. But it then says, and the Federal Capital Territory. So the question is and disjunctive or is it such that we now would say that we have 37 states. I don't think we have 37 states. We have 36 states. But then the question then would be, after having 25% of the votes cast in 24 states, should we then look in the direction of the Federal Capital Territory, more or less as a casting vote participant, to say, Federal Capital Territory, then you tell us what you think? I don't think we should have such a situation. Meanwhile, we cannot have 25%, two-thirds rather, two-thirds of 37. So we don't want to go back to the days of the 1979 situation. We had 12 two-thirds of 19 states. And I suspect that's why some people think we have 36 and we just stick to that. Otherwise, if we have the opportunity to amend our laws, we should simply state a figure and say you must have won 25% of the votes cast in 25 states as well as the Federal Capital Territory. Then that will make it clear. So we're not talking about calculations or anyone saying, well, should it be 24 states in addition to Federal Capital, or Federal Capital should be part of the states we're talking about. So I think to that extent, I agree with Sagbako, but there's a bit of ambiguity.
Now, every election year comes with serious pressure on our judges from politicians who are often aided by some lawyers, senior lawyers like yourself. But what more do you think we can do to shield our judges from corruption? And do you think that the bar is doing enough to instill discipline in its members?
Let me say this frontally. A judge does not need to be shielded from corruption. When a judge took an oath, the oath of office, it's not included in that oath and that I shall be assisted or protected from corruption. A judge realizes that the job that he or she has taken demands a lot of respectability, honor, integrity, and candor, such that when you sit as a judge, even when people approach you, you will know very well that this is a situation where you are going to be able to say no to what is tempting. For example, I don't know if you read the book by the late jurist Electoral, The Mystery Gunman, and he spoke about his experience with the premier who came to visit him, and without saying so many words, he said something like "Olonwe Ofunyeshe," and he understood what that meant. But he did what he had to do as a judicial officer. Judicial officers, with the greatest respect to them, they are peculiar human beings, and they must act as such. They must act in such a way that when we see them, we hold them in high esteem. We see them as awesome, and we know that these are people who are incorruptible. I remember a small book we used to read in the days of the secondary school days by D.O. Olagoke, The Incorruptible Judge. You must be incorruptible as a judge. So when people approach you, they should know that their effort at trying to get you corrupted, it's going to be futile. That's the way it should.
Now, my final question is this. What are your expectations for the new year, especially in terms of justice delivery?
My expectation for justice delivery clearly is that from now till the elections and after that, a lot of work will be geared towards the elections, the appellate courts, the Supreme Court. But let me say something to you. A lot of the courts will still entertain civil matters, commercial cases, will still entertain criminal cases. So they still have a lot of work to do. For example, I know that the Supreme Court has pending before them maybe about 6,000 appeals for 12 people to handle. So they're still going to be overburdened. They're still going to be overworked. And that is why on this occasion, maybe I should also lend my voice. More justices should be appointed for the Supreme Court, please, so that even the quality of the work they're going to be doing will not diminish because they're overburdened. But for the high courts, they will continue to work as usual, and never forget that the magistrate courts also, which a lot of us don't consider, do a lot of work, a whole lot of work. So I see things going on afoot, but we as lawyers have a role to play. And the role we need to play is ensure that we come before the court with only cases that are relevant to ensuring that justice is attained and our jurisprudence is enhanced.
Welcome back. The Lagos state government has arraigned ASP Vandi, the policeman accused of killing Lagos-based lawyer Bolanle Raheem on Christmas Day. He was arraigned on a one-count charge of murder at the Lagos High Court, sitting at the Tafawa Balewa Square. When the charge was read to the defendant, he pleaded not guilty. A member of his team, Inspector Matthew Ame, promptly testified as the first prosecution witness. He told the court that the car in which the late Bolanle Raheem was riding with members of her family did not have a number plate, and he was flagged down by the police officers during their stop and search along the Ajah Bridge area. The Lagos State Attorney General and Commissioner for Justice, Mr. Moyo Onigbanjo, who is leading the prosecution, has again restated the commitment of the government to ensure that justice is done.
This is in demonstration of the state's resolve that within all our powers, no crime will go unpunished, and that we will bring the full weight of the law to bear on anybody, particularly those who take the lives of our citizens in an unlawful manner. And so this is what we're doing. If you recall, this incident happened sadly on Christmas Day of last year, and today is the 15th of January 2023. And with the cooperation of the police, we've been able to marshal all that we need, the autopsy report, the statements of all the witnesses. The DPP has been able to give an advice, and as such, we are in court today to put the state's case across, and the defendant also will have his own say, and the court will decide the matter.
In furtherance of the commitment of the Nigerian Bar Association to ensure justice in the matter, the president of the Bar, Senior Advocate of Nigeria, Yakubu Mekiao, the chairman of the NBA Lagos branch, Ikechukwu Uwana, and other executives of the association were also present in court to monitor proceedings.
On the part of the Nigerian Bar Association, in consultation with the family of the deceased, we set up a committee that is headed by Adeluola, Senior Advocate of Nigeria. And those of you who were in court, you saw that they announced appearance, holding brief for the family to watch the proceedings. And we are here to demonstrate our commitment to pursue this matter to its logical conclusion. And that's what we would do, not only for Bolanle, who happens to be our colleague, but anyone who suffers as a result of the excesses of law enforcement agencies. Is a responsibility of the Nigerian Bar Association to look after every Nigerian. And that's the commitment that we're giving. That is why we're here. We'll continue to do that. Never again would matters like this be swept under the carpet. Under our watch, we will not let it happen.
The Defense Counsel also shares his assessment of the proceedings.
For now, our position is to cross-examine the people, the witnesses they have brought. A lot of mystery will be unraveled. You know, the PPRO has said it. There is a nice gentleman that may be in quote spiritual effect, but would show that it's not a spiritual. Let's get to the breach.
His trial will continue on the 25th of January with the testimony of a second prosecution witness. Meanwhile, funeral rites for the late Bolanle began on the very day the trial commenced. The Nigerian Bar Association held a rural tribute at the Nigerian Law School, Lagos, in her honor, after which they proceeded to the Olive Tree Parish of the Redeemed Christian Church of God, Banana Island, for a service of songs.
I see the incident that took the life of Bolanle as a sacrifice for something that has begun to happen in this country, for the kind of revolution that we require. It's unfortunate that it has to be Bolanle. It's unfortunate that we have to make a sacrifice of this nature to begin to gain the sort of traction, the sort of momentum, and the sort of attention that this has generated, and it's really causing a lot of changes already. I believe that this is a sacrifice that will cause that turnaround in this nation. And I believe that one way that all of us, not just the members of the Nigerian Bar Association, all of us together can appreciate Bolanle for the life that she lived, is to actually make sure that with everything that we have, with the privileges that we enjoy of being alive, and the giftings that we have of being members of the legal profession, we'll do everything possible to make sure that things of this nature do not happen again.
24 hours later, late Bolanle Raheem's body was brought to church for the funeral service, which was immediately followed by an interment at the Vaults and Gardens Mayfair Cemetery in the Bejuleki area. We'll keep close tabs on the prosecution of ASP Vandi Jambi and keep you updated on the show. And just before we go, let's quickly do a recap of some of the top trending stories from the courtrooms.
We begin with a report that the former Minister of Niger Delta Affairs, Senator Godswill Akpabio, has been restored by the Supreme Court as the All Progressives Congress senatorial candidate for Akwa Ibom North Senatorial District. The Apex Court set aside the Court of Appeal judgment delivered on November the 14th last year, which voided his candidacy. In a unanimous judgment delivered by Justice Ibrahim Saulawa, the Supreme Court upheld the judgment of the Federal High Court in Abuja, which in September last year granted verdict in favor of Senator Akpabio. Justice Saulawa, after reviewing the arguments canvassed by Akpabio, said that his appeal was meritorious and allowed. The Court of Appeal, Abuja, has upheld the nomination of Mr. Akan Udofia as the Akwa Ibom State governorship candidate of the All Progressives Congress. In a unanimous decision, the appellate court set aside the judgment of Justice Agatha Okeke of the Federal High Court, Uyo, which had nullified the May 26, 2022 APC primary, where Mr. Udofia emerged winner. However, the Court of Appeal upheld the judgment of Justice Okeke to dismiss the suit filed by Mr. Akan Okun, challenging the election of Mr. Omoeno as a candidate of the People's Democratic Party. Staying in Abuja, but this time at the Federal High Court, where Justice Inyangakwo has adjourned till March the 20th, the summons taken out for the Governor of the Central Bank of Nigeria, Mr. Godwin Emefiele, over a $53 million judgment debt arising from the Paris Club refund. No reason was given for the adjournment by the court. The court had summoned him on October the 20th last year following an application for garnishee made by Senior Advocate of Nigeria, Mr. Joe Agi, who is a judgment creditor. The dispute stemmed from an alleged $70 million judgment against Linus International Limited for the lawyer, Mr. Joe Agi's assistance with the Paris Club refund. Mr. Emefiele was said to have only released $17 million, leaving an unpaid balance of $53 million. The same Justice Inyangakwo has vacated an interim forfeiture of 40 landed properties granted against the former Deputy Senate President, Senator Ike Ekweremadu. Justice Ekwo gave the order following a discovery that the forfeiture order was fraudulently obtained by the federal government against the properties. While lifting the order, the judge held that the EFCC, which obtained the order on behalf of the federal government, concealed information that led to granting it. Specifically, Justice Ekwo said that EFCC, which was fully aware that Senator Ekweremadu was in custody in the United Kingdom, failed to make the vital information available to court. The judge agreed with the counsel to Ekweremadu and Senior Advocate of Nigeria, Adeluola, that there was no way the former Deputy Senate President would be opportune to defend his ownership of the disputed properties. Judgment in the 27-count fraud charge brought against a former head of service of the Federation, Mr. Stephen Orosoi, by the federal government has been fixed for April the 5th. The court fixed a date after EFCC, Mr. Orosoi, and others adopted their final addresses for and against the case. While adopting his final brief of argument through his counsel, the former head of service asked the court to dismiss the entire charges against him for lack of evidence. Mr. Orosoi was arraigned alongside the Managing Director of Frederick Hamilton Global Services Limited, Mr. Osarenko Afe, on a 49-count charge, but later reduced to 22. And we round off with the reports that the suspended Deputy Commissioner of Police, Abba Kyari, who is facing drug trafficking charges, has filed an application before the Federal High Court, Abuja, to quash the charge against him, maintaining that it was legally defective. In his motion, Abba Kyari held that the charge was premature, insisting that the NDLEA ought to have allowed the police to exhaust its internal machinery before it instituted the action, as the security agency had already commenced investigation on allegations against him. Kyari maintained that he could only be charged to court upon conclusion of the internal investigation by the police, and therefore urged the court to quash the charge and discharge him. Meanwhile, counsel for the NDLEA, Mr. Sunday Joseph, urged the court to dismiss the defendant's preliminary objections, which it argued was based on fundamental misconception of the law. The NDLEA further argued that if it was the duty of the police to investigate or prosecute drug-related cases, it would not have transferred such cases to it. Well, after listening to both parties, Justice Emeka Nwite adjourned the matter to March the 22nd for ruling.
And that's the program for today. If you missed any part of it, you can find it on past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shieli. Thank you for watching and see you next week.